Please. Good afternoon, ladies and gentlemen. Welcome to Dr. Olu Asekun podcast. Today is another beautiful Wednesday. Thank you for joining us. Wherever you may be joining from, remember to invite your friends, family, colleagues, and join us because today is a special one, Thanksgiving edition. In fact, some of our team members have to be recalled from Thanksgiving vacation for today's episode. We also have a significant update today, update that will affect hundreds of thousands of people. It's a new development that we are going to talk about today before we go into our questions and answers. So I'm going to tell you, if you have questions, start sending it in. Today is also the day we will be selecting the free consultation person. What are the rules this time around?
So they need to be subscribed to our channel, and
Subscription?
they need to comment live or free consultation in the live chat.
At the end of the program or
End
at
of
any time?
You're gonna let them know.
Yeah.
Okay.
They can start
Let them know
participating.
Okay. I've been instructed that to be eligible for the free consultation, you have to subscribe to our channel. And two, towards the end of the program, you send in a chat free consultation. Not at the beginning, because what we discovered from the previous edition was that the free consultation thing will prevent us from seeing the questions that are posted. So I will advise that you wait towards the end of the program. Remember, I'm not in court today, so we are going to have the full hour. There is no rush. But wait towards the end of the podcast before you send in the free consultation. When it is time, I will announce it. So once you hear the announcement from me, then you know that it is time to start sending in the free consultation. In the meantime, we are going to start as usual with the updates. So between last week and now, as we are already aware by now, this administration is not, there is no scarcity of updates. They are really, really, really anti-immigration, and they keep rolling policies that are anti-immigration. So the update for today, I have about 4 of them. The first one I'm going to talk about, there is an adjustment to some filing fees for employment authorization, travel document, and I-821. They were adjusted by about $10. They call it inflation adjustment. So I'm going to advise you, if you are applying for employment authorization or travel document, or even the renewal, either it is the original application or a renewal, I will advise you to check the update, to check the USCIS fee schedule before you mail in your application. Otherwise, it will be rejected. Many of the fees were adjusted by $10, $5, but again, the advice is make sure you check the update. Make sure you check the fee schedule on USCIS website if you are doing it yourself before you apply. Otherwise, you mail it in, they will reject it because the fee is incorrect. So that is the first thing. The fee adjustment is effective immediately. So it's something that is already operative. So it's not something that is going to be operational in the future. It's right now in operation. The second thing I want to talk about is that a federal judge in the Southern District of New York blocked the termination of TPS for Syria. I know that a couple of weeks ago, I mentioned that DHS has terminated TPS for Syria, but a federal judge in the Southern District of New York blocked it, that no, they cannot do that right now. So if you are from Syria, you can still apply to renew your TPS because a federal judge has blocked the Trump administration from terminating it. The next thing I want to talk about is also that DHS has announced termination of TPS for Burma. Burma, that's the country used to call Myanmar. So their TPS is terminated effective January 20, 2026. So if you are from Burma, you probably will no longer be able to renew your TPS. Now, the fourth and the significant thing that I want to talk about, I intentionally delayed to make it the last update I want to talk about today because I wanted more people to join us online so that more people will hear about this because, as I said, this is something that will affect hundreds of thousands of people. The Trump administration on November 21st, what is today? I think today is 26th. When was 21st? Friday. Okay. Yeah, you will notice that lately they are used to announcing policies on Friday night. Again, they did it this time around. On Friday, last Friday, the USCIS director issued an internal memo ordering USCIS personnel, that is USCIS employees, ordering them to reopen, rescreen, and interview all refugee approvals between January 20, 2021 and February 20, 2025, effectively covering the 4 years of Joe Biden. So if you enter the U.S. as a refugee or if you are granted asylum in the U.S. between January 20, 2021 and February 20, 2025, the memo stated that every case that was granted at that time should be reopened, should be rescreened, and should be re-interviewed. Now, the memo also ordered USCIS to stop adjudicating any adjustment application filed by any refugee or their derivatives, anyone that was approved. You know that normally when an asylum or refugee status is granted, 1 year after, they are eligible to apply for a green card. So what they are saying now is that all green card application that is pending, that is based on asylum or refugee, they must put a stop on it. They should put a hold on it. So those applications can no longer be approved at this time. They are all suspended. They are all on hold. Now, the memo also states further that USCIS has 90 days from the effective days to compile a list of cases to prioritize for re-interview. But however, the USCIS itself stated that they have determined that a comprehensive review and re-interview will be done to all applicants, all. So even though the memo said they should compile a list, but they have responded that they are not compiling any list. They are going to re-interview everybody that has been granted asylum or refugee status during this time. Again, the memo also directs USCIS to terminate refugees' grant if reviews find they were not eligible at the time it was granted. Again, what the memo is saying is that once they review and re-interview these people, if the new officer who conduct this review believe that the asylum was wrongly granted before, they should terminate it. So the memo went further. It says that once the refugee status is terminated, of course, any pending application for green card should also be denied. That's what the memo says. Again, The memo specifically emphasized the persecution bar, which means that if you were granted asylum before and you did not prove that you were actually persecuted by the government of your country, or either you have been persecuted in the past or you have a fear of future persecution, then you are not eligible for asylum. Even if you have been granted, it should be reopened and denied. Again, the memo also states that refugees who have already adjusted status, that is, if you have already been granted green card, you are also affected. This is where it becomes very, very dangerous. So what they are saying is, it doesn't matter whether you have been granted green card or your application for green card is still pending, or you have not even applied for green card yet. It covers everybody. For as long as you are granted asylum or refugee status between January 20, 2021 and January 20, 2025. That was the exact 4 years of Joe Biden. So anyone granted asylum or refugee status during this period, you have a reason to be concerned, especially those who may have even forgotten the story they presented. So this is what the memo is saying. So this is unprecedented in this country. Since I've been practicing immigration law, I've never seen anything like this. Looking at this memo, I foresee a lawsuit, because this is what is called retroactive. This is not even a legislation in the first place. This is a policy. I've always explained that there's a difference between the law and the regulation. There are three arms of government. We have the executive, who is supposed to implement the law. We have the legislature, who is supposed to be the one that passes the law. They are the one that makes laws. And then you have the judiciary, they are the one that interpret the law. So if the Congress that is supposed to enact asylum law, and they have already done so, whenever the legislature passes a law, usually they don't explain the machinery of how this law is to be carried out. That is where the executive steps in to provide what is called regulation. So if the law says this cup must be put on this table, it is the regulation that will explain the procedure to let the government know that this cup is now here. So those regulations is what the executive arm of government have control over. Now they are saying that people who have been granted asylum, they should go back retroactively to go and revoke it if they now believe that they are not qualified, including people who have altered their position, people who have been granted green card, people who have seen themselves as a permanent resident of this country. They are saying now that those applications, even the green card application that has been approved, all those things should be reopened. There is no way this will not attract litigation. Like I said, this thing was done last Friday, and I will update you on it. But I am almost certain that lawsuit will spring up over this matter. My own role is just to tell you what is going on. That is the update for now. How people will react to it, how American Immigration Lawyers Association will react to it, how what is that? ASAP, Asylum Seekers Advocacy Project, how they will react to it, how what's this organization in California, LULAC, will react to it, how there's this organization that always file lawsuit. There's this university. Well, the immigration community, how they will react to this, we still don't know. Like I said, this is brand new. They announced this on Friday night. You know this is Thanksgiving week, so many people may not even be aware of this thing right now. That is why we are bringing it up, because they were trying to. There is going to be a lot of element of surprise I can imagine somebody who believes that he or she is a permanent resident, and then suddenly they are saying that, oh, you need to come back and defend your application for asylum. That is ridiculous, in my opinion. But we will update you as we go. Now, we need to go into the questions. We've already spent 17 minutes on this, but it's worth it because this is something that calls for concern. And those who are U.S. citizens, if you are a U.S. citizen and you are listening to me today, don't ever believe that this thing does not affect you. They are only starting. We don't know where this administration is going to end. So when something is wrong, let us all rise up and condemn it. Let us all rise up. Call our congressmen, call our congresswomen, call our senators. This is not right. This is not right. We already know that this administration has doubled the rate of denials for asylum. To now go this far, to go and reopen, reevaluate, and probably revoke those people who have been granted, this is ridiculous. This is ridiculous, in my opinion. So I hope that if you are believing today it doesn't concern you, the next thing they will also go further, because I believe that our president, our current president, is testing the waters. He's really pushing the limit of his presidential power. He's pushing the limit of his presidential authority, and I don't have any problem with that. The only thing is we must rise up and let the government know when we have concern. My concern is the retroactive nature of this policy. There's nothing wrong with the policy. Even if you decide you don't want to grant asylum any longer, let the Congress pass a law and change the law. It's as simple as that. But for as long as the law is still in existence, the law is meant to be obeyed. America is a country of law. This is not a jungle. I remember when I was doing my own citizenship interview, one of the questions they asked during the interview is, what is the meaning of rule of law? It means nobody is above the law. So why is the government doing all this? Well, let's go into the questions.
People need to make sure that their address is current with USCIS, just to be sure that.
Okay, now one of our team members have called my attention to this. You see, there is going to be a lot of fallout in this policy. A lot of people, especially people who no longer have a pending application, people who have been granted green card, they may have moved, they may have changed their addresses. So when these things are reopened, what is going to happen? USCIS will send notice to the old address, and now these people may not see it, and then USCIS will now revoke it, saying that, oh, we asked you to come for interview, you didn't show up. Now they will put people like that in removal proceedings. How is somebody who is already a permanent resident going to be worried about being placed in removal proceedings, especially when he or she has not committed a crime? You see, there is going to be a lot of problems. So we are going to advise, if you are listening to me today and you believe that you may be affected by this new policy, I want to advise you, go and update your address with USCIS. Even if you don't have a pending application, go to USCIS website, download Form AR11, application for change of address, complete it, mail it to USCIS with a certified mail so that you have proof of delivery. So that if for any reason they sent anything out and you didn't receive it, you have those evidence with you showing that you updated your address. You provide your current address. Because, like I said, a lot of people, I don't even know what is going to happen to people who are already a U.S. citizen. Because if you are looking at the timeline, people who are granted between January 2021 to 2025, that's almost 5 years now. Some people may have joined the military and they may have become a U.S. citizen. Some people may have been married to a U.S. citizen, resided with a U.S. citizen, and apply for adjustment of for citizenship after 3 years. What is going to happen to those people? Are they still going to be affected? I mean, there's a lot of unknown. Again, I expect to see litigation in this case. I expect to see litigation. And I can assure you, apart from whatever litigation that AILA may be planning or ASAP may be planning, if I have a client who is affected by this policy, I can assure you I will go to court to challenge it. So let's start the questions. Do I have the first one? Is that the first one?
That was the first one.
Okay. The first question I have today, I moved to the UK as a single person in 2021, although I was separated from my previous wife at the time. In 2022, I married a US citizen and we had a court wedding in Nigeria. She filed for my immigration and I obtained my immigrant visa while in the UK. My previous marriage was later finalized, legally dissolved in Nigeria in October 2025. No. Something is not wrong. Can you go back to the very first question? I moved to the UK as a single person in 2021. Single person. So where did the issue of previous spouse come in?
I think he was actually married but separated.
Yeah.
But he said he moved as a single person.
Like, without a wife.
Okay. Although I was separated from my previous wife at the time, in 2022, I married a US citizen. That's bigamy. Okay, I just want to be sure that I got the questions correctly. I mean, whoever sent this question, you are already liable for bigamy, because if you were separated, separation is not divorce. If you are married, you have to be legally divorced. If all you did was to separate, you are still married. So you married a US citizen in 2022 who filed the paperwork and he got the immigrant visa. Okay, my previous marriage was later finalized, legally dissolved in Nigeria in October 2025. What implication could this have on my current status as a lawful permanent resident? It simply means that you obtain your lawful permanent resident by fraud. It's as simple as that. So you cannot build something on nothing. So your green card is going to be, anytime immigration becomes aware of this, your previous marriage, it simply means that your green card was obtained fraudulently. They are going to revoke it. That's the law. There's no way around it. That's the law. Even in some states like Texas, where the Texas law says that if you marry someone without previously terminating a prior marriage, that new marriage is void. However, upon proper termination of the previous marriage, the new marriage becomes valid from the date of the proper termination of the previous marriage if both spouses agree to remain married. But even under that situation, this green card will still be revoked, because it means that your marriage will, even assuming that this was a Texas case, it means that your marriage will now be legally valid from October 2025, which means anything that happened before that day is void. So it still does not save the situation. But Texas law cannot even apply here, because by immigration law, the law of the place of marriage is what is controlling. So wherever you got married, that is where the law controls. If you got married in Nigeria, the Nigerian law in the state where you got married will be the one controlling. And depending on the nature of the marriage, if you got married under the Act, it is the English law that will control it. That is the Act. But if you got married even under customary law, the green card will still be invalid. Either way, there is no way around it. Your green card will still be invalid. That's the truth. The only solution to this is, I don't even know if this person is still in the US or outside the US. My solution to this problem is If you are still together with your wife, let your wife file a new application for you. Start afresh before immigration brings it up, because if immigration brings it up, there is possibility that you may be detained while the process is ongoing. So it's better to voluntarily fix this before it becomes a big problem for you. But either way, this green card cannot stand. There is no way around it. That is the law. Okay, this is just a thank. Thanks for all you do, sir. You're welcome. Next question. Good day, sir. Will the I-130 filed at the same time but in different center for two children of the same parent will be treated at the same time irrespective of the different processing center? No. Every case is different. No two I-130s are adjudicated together. Even if they are filed at the same center, they will still be treated separately. So because every case depends on the officer who is handling the case. It is not the center per se that determines how cases are processed. It is more about the individual officer. So you see some officers, they don't like files staying too long on their table. If you assign a case for them, within few weeks or months, they have already dealt with it, they are done. Some officers, they don't care. Files may stamp on their desk. They don't care. So it depends on the individual officer if you are talking about timeline. Next question. Good day, sir. Please, can we include our tax return as part of evidence of I-485 application, even if we owe IRS? Yes, you can include it, but you must have explanation. For example, if you owe IRS, you must show that maybe you have a payment plan agreement. But what I'm going to tell you is that the debt that you owe IRS is also going to be considered in evaluating your income. Remember, the whole purpose of providing affidavit of support is to show that your derivative, your beneficiary, is not going to become a public liability. They want to know that you have enough income to take care of the person you are sponsoring. That is the whole purpose of affidavit of support. So if you have a debt, because owing IRS is considered a debt. So if you have a debt, that will also be taken into consideration in evaluating whether you have the financial capacity to actually sponsor this person, or whether this person will become a public liability. Is going to be a factor. But yes, you can still submit it. In fact, if you are the petitioner, you have to. Whether your income is sufficient or not, you still have to. If your income is not sufficient, then you need a joint sponsor. But the primary responsibility of the petitioner is to provide affidavit of support, including tax return. Even if you didn't file tax return, you have to explain, you have to include a sworn statement explaining why you did not file. Because if you have a responsibility to file a tax return and you didn't fulfill your responsibility, you cannot be asking for benefit from the government. So those are the things you will have to explain why you didn't file your tax return, even if you don't have income. You still have to provide those things and provide an explanation. Next question, please. Hello, sir. There's no question with that, just greeting. Okay, next question. Please, sir, if my I-485 application was not submitted through e-filing, can I send additional hard copy evidence to USCIS without their request? Well, you can't even submit I-485 by e-filing in the first place. It's not an application that you can e-file. So the only way you can do it is to send it to USCIS by mail. However, I'm going to advise you to keep your evidence. Start gathering your evidence. You don't have to send it in until they invite you for interview. One of two things is going to happen. If immigration believe that your evidence is not enough, they will issue a request for evidence, initial request for evidence. They will issue it. Once they issue it, you respond to it. The second option that could have happened is they are still going to invite you for interview. Under this new administration, every case, even employment-based cases, most cases are getting interviewed during this administration. So put your evidence together, continue to compile it, and wait either for a request for initial evidence or wait for interview. The reason this is important is because USCIS, they are extremely good at misplacing documents. They are very good at it. And it is because of the system, the way the system is processed. When you mail a document to USCIS, it doesn't go to the officer who is handling the case. For those who have been in this country a long time, you will remember the time of anthrax attack, when people will put dangerous chemicals in envelope and mail it to USCIS. And then anybody who opened those documents will now face the attack and all those things. Since that time, they have changed the system such that documents do not go directly to USCIS officers. Documents go to lockbox facilities where you have people who are dressed up as if they are going to the moon. They are the ones that open these envelopes now and test it to be sure that there are no harmful chemical or anything. So once they open it, they are the ones that will now send it individually to places where those documents are supposed to be. So documents get easily misplaced when you mail it to USCIS without a request for evidence or without an interview. So on the other hand, if USCIS send you a request for evidence, they always tell you that when you respond, the request for evidence letter must be placed on top of your document. The reason for that is that as soon as they receive those documents, they scan it and it tells them exactly where that document should go. If you send your own document without the RFE, you are not going to have those kind of information. And at the end of the day, your document, the likelihood of your document getting lost, I will tell you, is going to be about 75%. So what's the point? So gather your document, continue to gather your evidence. Whenever they invite you for interview or if they send you an RFE, that is when you respond to it. Next question, please.
If they send you a letter to create an online account, then you can do that. And sometimes, if your case is eligible,
This is I-485. There's no.
They do. Now, sometimes they'll send you something in the mail after the receipt notices where they tell you how to create an online account. And
Okay.
in some cases, they let you upload evidence that way.
Okay. I've been reminded here by my boss, my team members, that sometimes USCIS send a letter asking you to create an online account. So if that happens and you have created the online account, you may be able to upload those documents. So if you upload it, it's going to go directly into your account. So there is no possibility of the document getting lost in the mail. So if you have an online account, if you have received a letter from USCIS asking you to create an online account and you have created it, then you may be able to upload it. But if you are going to mail it to USCIS, no, you cannot do that because the possibility of getting lost in the mail is very, very high. And I-485 is not one of the applications you can e-file. Next question, please. Okay. Good day, sir. And thanks for your help always. You're welcome. Please, sir, my friend's son that's in active military has an issue related to good moral character. So based on this, he was denied his citizenship. So can you move it on? So he appealed and was scheduled for hearing, but he didn't receive the mail. What advice can you give him? So how did he know he was scheduled for hearing if he didn't receive the...
Maybe online notification.
Well, but the question is not complete. So he didn't say whether whether the interview date has passed or it's something. Well, first thing, call USCIS. Call them and try to explain to them that you have not received the notice of hearing. And if you are not able to call them, is there an option for service request for that kind of? Okay, yeah, you can also do a service request to let them know that you didn't receive the letter. If you also have an online account, because I know this is citizenship, citizenship can be e-filed. That one you are easily going to have an online account. If you also have an online account, if you log in into your account, there is a button that shows document. So if you click on that button, any mail that was sent to you, you probably will see copies of that document in your online account. So that is another thing you can do. But if the date has already passed, well, if you have an online account and the document was posted there, then it's not going to be USCIS error. So you will have to refile. But if the document was not posted there, or if it was posted late, then you can still file what is called a service error request, asking USCIS to resend it because you didn't receive it. But if they uploaded it and you are the one that didn't check it, then you have to refile your application for citizenship. Next question. But based on what this administration is doing, if your son already have an issue with good moral character, that's going to be something difficult to overcome during this administration. Okay, next question. Good afternoon, sir. I entered with Iwi, but has since traveled out twice on advanced parole. After the parole, my son turned 21 and filed I-130 and 485 concurrently for me in 2021. Is there a continuation? Okay. From the filing, I got 5-year EAD while the case penned. In 2022, I got interview but later got a notice that the interview I attended was cancelled. Entered. Is it answered? Okay, I probably entered. I entered Iwi. He said, although you did a lot of things wrong, but we can make it work. Is it safe to travel with the I-512, or is it a trap to let me got out, we heard the... I'm not understanding a lot. He said, although you did a lot. Who is that? Who is he referring to? Is there another one?
So she wants to know if she can travel with the advance parole document when she entered the way, right? Is that her question?
Well, if there's no, well, I don't know. There's a lot of things that are not clear for this question. But if your question is whether you can travel with the advance parole document or not, if you do not have any criminal record and you have the advance parole document, yes, you can travel with it. However, remember that this administration and even the BIA, the Board of Immigration Appeal, recently, maybe last month or so, they have ruled that advance parole for Iwi entrant is not an admission for adjustment of status purpose. So, but since your adjustment application is still pending and you do not have criminal record, can you travel? Yes. But will your pending adjustment application be denied? The probability is, I will say, is more likely than not that the I-485 will be denied based on the current policy. All these things you mentioned in your question, they were things that happened during Biden administration. The policy in place at that time was in your favor, but things have changed. And to be honest with you, except it is extremely mandatory for you to travel, I will not suggest it's a good idea, because what if you travel and the I-485 was denied while you are abroad? Then when you come back, the possibility of you being detained and being placed in removal proceedings will be high. So I will not, can you travel? Yes. Is it something I will do? Except it is extremely important, I will not. So that would be my position. If that is your question, that is what I understand from what you asked. Next question, please.
People already comment the free consultation. But
No, it's not time to, is it? What's the time? It's not time for, when it is time for free consultation, we will announce it, please. You can see that I'm wearing casual today, so I'm not going to court, so relax. You'll get the free consultation. Okay, next question. Thanks, sir. Can I file for citizenship with a DUI? USCIS already know about it and approve my 10-year afterwards. Okay, if I understand correctly, this is before you got the green card. Yes, you can apply, but I would suggest that, I don't know the category. If the category is the one that is less than 5 years, I will ask you to wait until you are 5 years. Even if your category is 3 years, wait until you have 5 years. The reason is that the law itself states that the first 5 years of your legal admission into the US, which for this purpose is when you got your green card. You remember that whenever your green card is approved, they will send you a letter telling you welcome to the United States. Not that they didn't know that you have been living here for years, but that is when you are admitted to lawful permanent resident. So the 5 years start counting from that day. So the period of proving good moral character for the purpose of citizenship is 5 years immediately after your green card. So if this event occurred before you got your green card, just wait 5 years and then apply for your citizenship. It will not come up at all. But if it is less, if you apply at any time that is less than 5 years, because the law give immigration the opportunity to ask questions for 5 years, they may still be able to extend it to your citizenship application. Remember that the requirement of green card is different from the requirement of citizenship. So this DUI may not affect your green card, but it may actually affect your citizenship. So the solution to it, just wait 5 years after your green card, so that 5 years that is required for you to prove good moral character, it will not be affected in any way. That would be my advice to you. Next question. Have VAWA pending. I've received 2 primary fasces. I applied for a job at Houston Processing Center for job, and I was given the offer. Unknowingly, it's ICE office. Went for interview and offer letter was no, I'm sure they will not even hire him once they find out he's not a citizen.
that's the second part.
Okay, offer letter was sent. Should I be worried for I'm feeling scared of working there? No bad record of any at all. Well, the truth of the matter is, if you did not lie in your application, yes, you can take up the job. But you have to be sure that you did not lie in your application. Let me tell you something about government work, especially federal government work. After they offer you the job, they are going to conduct background check. This background check, they are going to talk to everyone that is related to you, that they know about you. They are going to go into your background to know where you came from, because you are going to be working for government. They want to know that you will not be you cannot be an asset, a negative asset. You are not somebody that can be used to kind of maybe put some how do we say this thing? The word disappear from me. To sabotage, is it sabotage? No, a kind of
To
to
assist or like
no to kind of use you to maybe as a bargaining tool. There's a word for it. I just can't
Leverage?
remember. Huh?
Leverage?
Similar to leverage, but it's not that. You see, the point is, every government employee, they want to be sure that you are not going to be a negative liability to the government. Maybe you are not going to be an instrument that they can use to maybe to sabotage the government or do something. So they are still going to conduct background check. Let me tell you, FBI agents are still going to interview you. So the fact that you got the offer letter is not an issue. But the truth of the matter is that for as long as you did not lie, if you complete Form I-9, Form I-9 they ask you, are you a citizen of the United States? Are you a national of the United States? Are you a lawful permanent resident in the United States? Are you an alien authorized to work in the United States? All those questions are there. For as long as you did not lie, there's no problem. But if you lie, not only will they revoke the offer, but you may be in trouble because that will become a criminal offense, lying to the government. That will be a criminal. But if you didn't lie, so honestly, I will take the offer. But like I said, there is still more to the process. It's not the offer letter is just the beginning. That is what we allow them to.
The last two people are commenting. Is that the word that you were looking for?
sellout?
Sellout or espionage?
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 Oh no, not espionage. Espionage is more like spying. No, this one is more like
Sellout? Someone else is saying sellout.
well, sell out too may be close, but it's like they is this sabotage when they use somebody as an instrument of bargaining. Blackmails. Yeah, blackmail is the word I was looking for. Blackmail. Yes.
I thought you meant like a Trojan
No,
horse
no,
kind of
no,
like the
no,
espionage
blackmail.
thing.
Yeah, they don't want you. They don't want you to be the instrument of blackmail. Yes, so they will conduct a extensive investigation. FBI is still going to conduct an extensive investigation about you. So the offer letter is not the issue. But like I said, if you did not lie, if you don't have any baggage in your background, there is nothing to worry about because the truth of the matter is that ICE is actually looking for people. In fact, I've seen so many advertisements on television. They were actually looking for people. They need people. They don't have enough employees. At least they don't have enough people to do what the Trump administration wants to do. So I see advertisement on TV all the time. So it may be intentional. They may want to hire people they believe that they have a likelihood of getting legal, getting their green card or anything. But the most important thing is do not lie in your application and make sure that your background is clean because they are still going to conduct. Because once you are engaged by ICE, do you know who your employer is? The United States Department of Homeland Security is your employer. So you are not going to be working for Homeland Security without clearance. So you are still going to go through a lot of background check, irrespective of what you are doing for them. Even if you are a gate man, you are still going to go through extensive background check. So the offer letter is just the beginning. So if you didn't lie, nothing to worry about. But if you did, once they give you the offer letter, just reject the offer. Sorry, I'm no longer interested. So just reject it. Case closed. Next question, please.
What would happen if their case was denied then, though? Do you really want to be
That's why it's dangerous.
It's like you're turning yourself in. No?
Okay, my team members here ask what happened if your case is denied after they employ you. definitely you now have to turn yourself in, because from that moment you become an illegal alien. So, I mean, it's not a good idea, honestly. Just reject the offer if you have not accepted it yet.
The person that asked the question earlier about the DUI,
Mm-hmm.
applying for citizenship, he said the DUI occurred in 2018. He got his temporary green card in 2016, and his 10-year green card was approved in 2021. So when he
Oh, it's
was,
already more than 5 years, then he can apply. I just want to make sure that the time of conviction, not the time of the event, the time of conviction, there is 5 clear years after the conviction for DUI. So if the conviction was in
so he got his
2018,
green card in 2016, and the DUI he got it in 2018, 2 years later.
yeah, but when was the conviction? It's one thing to get DUI in 2018, but when did the case end? The immigration start counting from the date of conviction, not the date of the arrest. Somebody can be arrested for DUI in 2018. The case may be ongoing for up to 3-4 years, especially if the criminal defense attorney is trying to make sure that maybe they ask the person to attend some classes to be able to show that the person is a changed person. They may delay the case. So it is the date of conviction when the case ended. That's when you start counting the 5 years. So if it is more than 5 years, then you can go ahead and apply for citizenship without any problem.
Okay.
But if it is still within the 5 years, then just wait. Okay. What's the next question? Okay. Good day, sir. As a green card holder through marriage, I'm reaching out for guidance on my daughter's immigration status. She'll be turning 18 next year and currently reside in Europe. So what's the question? Okay, I'd like to know if I need to submit an application on her behalf before she turns 18, or if I can wait until she's 21. No. First and foremost, this person didn't indicate whether he's still with the US citizen since he got his own green card through marriage, because your US citizen spouse can actually petition for the child, and the cutoff age is 21, not 18. So your spouse can petition for the child. On the other hand, you as a permanent resident can also, for as long as your green card is 10 years, you can also petition for the child, because the child is still within the definition of family until the child turns 21. So it is better to do it now. And based on this fact that you have presented, I will suggest that you do it yourself, because there is not a whole lot of difference between you doing it and your husband or wife, the US citizen spouse, doing it. So why not do it yourself? Because what if along the line the marriage failed? I'm not praying that your marriage will fail, but I'm just giving you the possibilities of what could happen in the future. What if the marriage fails? You will have to start all over again, because now that will require you, the child, to prove that he has a continuing relationship with somebody who is probably now your ex. But if you do it yourself as a permanent resident, like I said, this is still within the definition of immediate family. So your child will be here in the US before she turns 21. So don't wait until 21, because 21 is actually the cutoff date. Once your child turns 21, he or she will no longer be regarded as your immediate family. She becomes extended family member, and that will change the narrative. The waiting period for extended family could be up to 7-8 years, whereas for immediate family, from the word immediate, cases are processed immediately. So you can go ahead and do it now. File the I-130 for her right now, so that this can be resolved before she turns 21. Next question, please.
Somebody just saying hi there.
Oh, okay. Hello, doctor. Thank you. Hello. Okay.
Sorry, the N400 question, the DUI, saying that the conviction was February 2018.
Yeah, that is already more than 5 years. Yeah, I've answered the question. He can go ahead and apply for citizenship. That's no problem.
That's the next question right there.
Dr. Asekun, you are great and the best. Thank you. Thank you, sir. It is my prayer that the unfailing arms of the Lord will guide you in life and everything you do. In the mighty name of Jesus. Amen. Amen. Thank you. Thank you so much. Amen. Can you scroll up? Is that a follow-up question or just a prayer?
Let me see. I don't see any.
Okay. Thank you so much. Go to the next one.
Yeah, I'm trying to go back there.
Okay.
Okay, this one.
Okay. Good afternoon, Doctor. Happy Thanksgiving to you all. Thank you. Happy Thanksgiving. God bless your heart. Amen. Amen. Can a lawyer sue us if we ask congressional help? We informed the lawyer, but did not say anything, and later said we can be sued. No, you can. They cannot. Asking for congressional help does not affect the lawyer, so no, you cannot. And if they do, it will fail. The congressional intervention does not in any way affect a lawyer's work. So there is no, don't let the lawyer discourage you. It doesn't in any way. It's not going to affect you. If they sue you, come back to me. I will defend you for free. Yeah, they can't do that. Next question, please.
You want to go to that one? The one in yellow.
Hello. How do you advise a person that filed for naturalization but has a pending criminal case that has not been accused yet? The person received the 48-month extension but never received the 10-year green card. This person is not a permanent resident yet. Is not a permanent resident yet. So there are so many things. Number one, USCIS is not going to adjudicate the citizenship application. They are going to put it in abeyance. They are not going to adjudicate it. Number two, even the 10-year green card, they will not adjudicate it until the criminal case is over. For as long as USCIS knows that a criminal case is pending, they are going to put your case in abeyance. They are not going to deny it and they are not going to approve it. They are going to wait. They are going to wait for the outcome of the case. This is because an accused person is presumed innocent until the person is convicted. What?
Just said the person is an LPR.
No, he said his 10-year green card is still pending. That's what I read there.
Yeah, and it said that they just have the
You just
extension.
sent a new message saying the person is an LPR.
They're conditional.
They are not LPR. If what they have is conditional green, there's a difference between a permanent resident and a conditional resident. They are not the same thing. I know exactly what I'm talking about. They are not the same thing. The reason they put the condition is that they don't believe you yet. And it is not only marriage based. Even investors, those who invest $1 million, 800,000, they get conditional green card too. So the reason is they want to know that those things you are supposed to do, are you going to do it? So that's why they give you that condition. So your permanent residence is based on the fulfillment of that condition. So until the condition is removed, that's when you become a permanent resident. For now, you are a conditional permanent resident. So if the condition is not removed, you are not a permanent resident. So I know exactly what I said. So because you still have the extension, that means the condition has not been removed. And I'm telling you now, based on what I know, based on the regulation, based on my experience, that with the criminal case still pending, they are not going to adjudicate your case because they cannot predict the outcome. What if they approve it and then you are now convicted of something that disqualifies you from getting green card? Or what if they deny it and then your case is dismissed? which means you don't have any criminal conviction. So they cannot preempt the outcome of a criminal case. So what the regulation says is that they should put the case in abeyance. So they are going to continue extending your conditional residence until the case is over. I've had clients in the past whose cases lasted over 5 years. USCIS didn't adjudicate it. They have to wait because they can't determine ahead of time how the criminal case is going to go, whether you are going to be convicted or whether the case is going to be dismissed. No, they will not.
So the person that asked earlier about the congressional help,
Yes.
she's saying, "Oh, thank you so much, doctor." He said it's breach of contract, but I trust your wisdom.
There's no breach of contract. There's no contract that says you cannot seek help from a congressional liaison. No, there's no such thing. Even if they put that clause in your contract, that will be unconscionable contract. So don't worry. Like I said, if they sue you, come back to me. Write today's date. Remind me that I said it live. I will defend you for free. Next question, please. Okay. I submitted my I-130 in April 2025. We attended interview in May. USCIS requested RFE after 1 week. We submitted it and was received on June 15. Is there a follow-up? So there's no question.
No. Do you see anything? No. No, sir.
So without a question, there's nothing to answer.
Yeah. Okay. Next one.
Okay. Next question. I entered. I think we already.
Yeah, you're right.
Happy Thanksgiving to you and your great team. Thank you. Happy Thanksgiving. Okay. I and my wife's B1, B2 visa was revoked with no details given, but 22 CFR 41.122, we both live in the UK, and I also have an H1B application in administrative processing for over a year. Please advise. Good question. American law is different from most other countries in the world. The United States Congress, that is responsible for passing law in the United States, they gave what is called discretionary authority to consular officers. So what that means is that decisions affecting non-immigrant visas are discretionary. So the United States courts, the Court of Appeal, I don't know if there's a Supreme Court case on that issue, but the United States courts have ruled that where a discretionary authority is granted to an officer, the court cannot force them to use that discretion one way or the other, because the moment a court is able to tell them how to use the discretion, it is no longer a discretionary authority. And for that reason, they cannot change or alter any decision taken based on discretionary power. So what am I saying here? Every single non-immigrant visas, B1, B2, H1B, R1, O visa, L visa, F visa, M visa, every non-immigrant visa, they are 100% discretionary. So there is no room for appeal. There is nothing you can do. Incidentally, both of these cases that you mentioned, they all fall into non-immigrant visa category. So unfortunately, there is nothing you can do. If the H1B is still in administrative processing, all you can do is wait. There's nothing else you can do. This is not one of those cases where you can go to court, because like I said, Congress gave them discretionary authority and there's nothing you can do about it. That's why consular officers, American consular officers, That's why they can deny people visa with no reason. There's nothing you can do because it's a discretionary authority. You can't challenge them. That's why they can revoke visa at will. There's nothing you can do about it. You can't challenge it because it comes from a discretionary authority. So it is nothing, there's nothing we can do about it. Just wait for the H1B and pray that they will show you favor. That's it. Okay. Next question. Good day, sir. Thanks for all you do out there. Thank you. I got my green card in May 2023, and I also filed the same in October 2023 for my son, who is 19 years old now. I haven't heard from USCIS after the
initial.
Is there a continuation?
After the initial.
Oh, okay, after the initial acknowledgement. Do you advise I file adjustment of status for him as he is presently in the USA on a F1 visa? Please advise, what can I do to move your application forward? Okay, now, there are questions you need to answer or there are issues you need to clarify before I can tell you whether you can apply for adjustment of status or not. Number one, what is your priority date? Is the priority date current? Number two, since your, is it son or daughter? Since your child entered the United States, has he been maintaining legal status? So if the answer to both of them is yes, if visa is current and your child has been maintaining legal status, yes, you can submit application for permanent resident on his behalf. Because the fact that he's on F1 does not mean that he's been maintaining legal status. F1 can be terminated if somebody entered into unlawful employment. F1 can be terminated if somebody does not register the required number of credit hours. F1 could be terminated for a lot of reasons. Somebody may be on F1 and may have been out of status. So you need to verify if your child is maintaining legal status, and you also need to verify if your priority date is current. If you tell us now what the priority date is, we can help you check the visa bulletin to see if visa is current. Can you please check visa bulletin? That should be F2A. Children of a permanent resident. So while they are checking, let's go to the next question. While they are checking, but at least those two things,
F2A.
F2A.
February 1st, 2024.
Okay, so the priority date is February 1st, 2024. So if you file your application before February 1st, 2024, then and your child is maintaining legal status, then you can apply for adjustment of status. But if visa is not current, they will reject it. And if your child is not maintaining legal status, they will deny it. So those two things must be in place. So was this filed before February 2024? If the answer is yes, was your child maintaining legal status? If the answer is yes, then you can submit application for adjustment of status. So let's go. Next question. Hello, doctor. I called the office to confirm if my I-589 has been reviewed. I was the one that informed you of an interview on Fox News.
Let me see if there's anything else.
I think I got
I don't see
a
anything
message.
else.
Okay, remind me after the podcast. We'll get back to you immediately after the podcast. But yes, it's been reviewed, and I think I sent some messages to you. Okay, we will contact you after the podcast. Next question, please. Can you quickly check if that person sent the priority date?
No.
Okay. In the meantime, next question. Thanks for all you do, sir. I'm on an R1 status and I have a priority date of February 2025. My question is Is it advisable to travel to Nigeria for visa stamping since that's the only option? No, this person didn't state when the R1 is going to expire.
And there's no follow-up question.
Okay, go back to the question. Let me read it one more time. I'm on an R1 status and I have a priority date of February 2025. R1 does not have priority date. It's only I-360 that have priority date. So maybe the person is mixing things up. My question is it advisable to travel to Nigeria for visa stamping? Well, if all this person want to know, if you are on R1, number one, there's no issue of priority date with R1. That priority date is only for immigrant visas. Immigrant visas. That is what priority date affect. I-130, I-140, I-360. Those are the kind of things that priority date affect, not a non-immigrant visa. But if the question is you are on R1 and you want to get the R1 visa, yes, the new procedure is that you have to go back to your home country. They no longer approve non-immigrant visas in third country, like going to Canada, going to Mexico. They no longer approve it. They will tell you to go back to your home country. Now, whether you should go back to your own home country or not depends on a number of factors. Especially, I see that the person who sent this question is from Nigeria. You have to be careful. Number one, before you came to the US, did you come to the US as a religious worker, or did you come to the US with a visiting visa and then change to R1? If you enter the US as a religious worker, if you came with an initial R1 that is now expired and you want to go and renew, yes, I will advise you to go. But if you came in here with a visiting visa and then you change your status to R1, I will not advise you to go. The reason is very simple. In Nigeria, especially with Pentecostal churches, the system is completely different to the US system, and it is foreign to the US system. In Nigeria, a lot of Pentecostal churches, they do not require their pastors or ministers to go through Bible college. They do not require their pastors or ministers to have a seminary training. People who are professionals, they are promoted pastors, they are ordained pastors. There are lawyers who didn't go to Bible college and they are pastors. There are accountants, there are engineers, there are doctors, people who have nothing to do with seminary and they are appointed pastors under the Pentecostal system in Nigeria. If you already have information at the embassy, listing yourself as a professional, and now you want to go back to the same embassy and tell them that you are a pastor. Remember, R1 requires you to be a full-time pastor in the US. So you may be at risk of having your visa denied. And if your visa is denied, you are going to be stuck in Nigeria. So for that reason, I will not advise you to do that. Next question, please. Okay. Good afternoon, sir. Thanks for all you do. Please, can a 2-year green card holder be a joint sponsor? No, you are not even a permanent resident yet. I just answered that question earlier. Wait until you get your 10 years. You are still standing on one leg. So somebody standing on one leg, you are attempting to carry somebody else. Both of you will fall down. So the answer is no. Next question, please. Hi there, Dr. Asekun. Thank you for all you do. That, thank you for all that you and your staff are doing for us. Thank you. You're welcome. I pray God you mention my case. I will send it in 3 phases. That's how desperate I and my family is now. Okay, so let's start from the first phase.
Looking for it? Okay, here.
This is 3.
Where's the number one? How did I
I see
miss
it
it?
here.
Okay, this one? Yeah.
Okay. Number 1, I applied immigrant visa I-130 for my family, wife and children underage, all underage, in 2021. After a congressional intervention, my wife was invited for interview to hold in Lagos on December 11, 2025.
And then
Okay, 11 and
December.
17.
Uh-huh.
Okay, where is number 2?
Number two.
I only see go to 3.
I don't see number two. Only number three.
Okay, let me just go to number 3. Now, my family and the kids went for their medical only for us to realize that only my wife was granted the medical. We were told that all children needed their ID, case number.
It's the same. Well, it depends. Let me see. This is number four.
I contacted USCIS. USCIS has nothing to do with this. And the NVC. The USCIS stated that my case is closed. Yes, USCIS has nothing to do with it.
Yes.
And the NVC is saying that my case is with the embassy. They are very correct. I've contacted Lagos. Oh, is that the number 2 we were looking for before?
Yes. That's number three already. I am yet to hear from the
Is
embassy.
this continuation from?
Yes.
Okay. I'm yet to hear from the embassy. Time is of the essence for us. My children are waiting for their invitation to have their medicals. I believe it should be the same invitation.
It's the same.
Okay. You want to answer it?
And there's a number 5 as well.
Oh, there's a number.
Oh, there's a number 5. Let's see what the number 5 is.
Oh, no, okay,
I don't see any other. No?
my case is no longer with both USCIS
Yeah, we
and
read that.
NBC.
Okay. Yes, you're right.
Yeah.
Sorry, I was told.
Okay. Sir, I was told that since my case is no longer with both USCIS and NVC, but with the embassy, I should contact embassy to unlock my DS-260 to enable me add my children. I've sent them email. I don't think that is right. But let me allow the person who handle the consular. Oh, there is more.
It looks like it because he didn't finish his whole question. I don't see anything
No, I
else.
don't
Do
see
you?
anything else. No.
Okay.
Okay. I don't think you need anything, but I'm going to allow
I have questions.
the
too.
person who handles who deals with the embassy in our office so to answer this. Just
Okay, I think I would need to go through the whole question again. I'm coming. Do you see it?
You want me to screenshot them so I can do them?
Yeah, because I'm going through the whole thing here. Okay, he applied for immigrant visa I-130 for my family, wife and children, all underage. But is he a permanent resident or a U.S. citizen? I don't think he said that. Did he say it?
Answer it both ways, assuming it's a citizen.
Right. So if he's a U.S. citizen, then he should have filed a separate I-130 for each one of them. That's the difference, right, between U.S. citizens and permanent residents. But if he filed for his wife and children as a permanent resident, then yes, only the one I-130 should have been filed and included the children in there. If that's the case and the wife got called for an interview, then all of them should have been included within the same case number. Now, if he filed for those children and the wife as a U.S. citizen, sorry, I'm hearing myself twice. Sorry. Yeah, it's confusing. So if he did file as a U.S. citizen for the wife and children, then that means that each one of them will have a separate case number because they are all treated separately. So, but they will all get different interview letters in each one of their names. In that case, then yes, each one of them will have a separate case number. Otherwise, if he just filed as a permanent resident for the wife and the children at the same time, then yes, it will be the same case number for all of them. Yeah. Hopefully that should be clear.
Thank you. Well, my understanding of the response is that if you are a U.S. citizen, you are required to file an individual I-130 for your children, for your wife, and for your children. But if you are a permanent resident, the same I-130 that you file for your wife covers your children. And in the appointment letter, your children's name should have been listed in it. So we need you to clarify whether you are a U.S. citizen or not. Because if you are a U.S. citizen and you didn't file separate petition, unfortunately, that is not something that it's not a problem that can be fixed at this stage. But if you are a permanent resident and then you file for them, you file for only your spouse and your children are not included, that is the one that can be fixed. But your children's name should have been included in the petition. So you may need to go back to the congressman that help you reach out to the embassy. But if you are a U.S. citizen, that would not even work because that is the law. The reason for that is that when a U.S. citizen petition for children under 18, once that petition is approved, the children don't get green card, they get automatic citizenship. But when a permanent resident petition for children, the children are given green card only. They are not given citizenship. So that is why the procedure is different. So if you are a U.S. citizen, you need to file an independent petition, I-130 petition for each one of your children, because once that petition is approved, they are going to get their citizenship. That is why that requirement has to be followed. Next question again, please. And let's see if we clarify whether it's a citizen or not.
Okay, you already answered to that one. This one.
Okay. Happy Thanksgiving in advance, sir. Happy Thanksgiving. Did he move?
He moved. Yeah.
Okay. Happy Thanksgiving in advance, sir. Why would someone asylum immigration court proceedings hearing continue to be adjourned severally? Does that help the case? Well, every case is different. It's not easy for me to determine whether it helps or not, but every case is different. So I'm going to tell you, in some cases, it may be a plus, but in other cases, it may be a problem. So every case is different. So without knowing the fact of each case, the details of each case, it's difficult for me to determine whether this is good for you or bad for your case. It's already 1:25. I think people should start. Let's determine a cutoff at this stage.
Oh, we should have done that.
Yeah, but well,
Okay.
let's determine a cutoff time, and then I think people can start sending
Maybe
the.
you want to tell us the next 10 questions and then we'll stop or
Yeah.
something like that.
Okay,
'Cause
yeah.
it's going to be.
Okay, now it's already 1:25. We are going to answer the next 10 questions, and then even now, because I believe we have up to 10 questions there.
We have many more than that.
So can you check how many do we have right now?
Okay.
I want to see how many we have because this is the time to start the free consultation thing.
Giveaway.
Yeah. irrespective of the number of questions we have, I think this is the time to start charging free consultation. If you are online and you want the free consultation, this is the time
just
to start.
remind them of the rules. They need to.
Again, the rule is that one, you need to be subscribed to our channel, and of course, you also need to be live. If you are not live, you won't even know when to start. So, if you are chatting, it means you are live. That's easy to meet. But I just want to know how many questions are left so that we determine the cutoff. Oh, you are still counting 20 something?
Yeah.
No, there's no way we can start. Okay, we are going to answer the next 10 questions.
From the one that you answer now.
Yeah, the next 10 questions. And if you are online and you want to participate in the free consultation draw, this is the time to start sending the free consultation chat. Yes. So just chat free consultation in order to be eligible. Okay, next question.
Okay. So that's the next one right now.
Okay. Which one?
I'm sorry, moved it because people are commenting now and it's going to start moving it. Oh my God.
Okay, it was.
Okay, so God bless this beautiful chamber for the good work.
Okay, that's a great thing. Okay, I got a speeding. Let me just. Okay, I got a speeding ticket, and it's my first time. Do you advise? Oh my God.
Yeah, it's gonna start moving in now because people are already commenting.
Here, I can.
Yeah, is there a way to stop it? Because I can't read the questions.
Here, I'll screenshot.
Oh, I think it's right on the. I got a speeding ticket, and it's my what? I can't see that. Oh, it's my first time. Do you advise that I got to court and request for a defensive driving course than paying? It doesn't matter. Either you pay or you do defensive driving. This does not affect your immigration status. Speeding ticket does not affect immigration status. Just make sure you don't allow it to lead to arrest. If, for example, they ask you to pay some money, if you go to court and the court asks you to pay some money, if you don't pay it and then, or maybe they ask you to appear in court and you fail to appear, those are the kind of things that can be problematic. But speeding ticket by itself does not affect your immigration record. It doesn't matter whether it's the first time or not. It doesn't affect you, so there's nothing to worry about. The benefit of the defensive driving is for it not to affect your driving record, and it will not affect your insurance, because your insurance policy premium may go up if you just pay without doing defensive driving. Defensive driving comes with a dismissal after the initial probation.
Okay, so you're gonna start from that question.
This one,
Yeah.
right? Okay.
Because that's just going to keep moving. So
It's gonna keep on moving, yes.
yeah, we're
Okay.
just gonna do it that way.
Okay, thank you.
Sit down here.
Okay, the next question. Good day, sir. God bless all that you are doing for us. Amen. I'm a student in the UK. Visa expires June 2026. My I-130 is at NVC. Can I request for my interview to be in the UK? The rejected I-129 last year was in Nigeria. Well, yes, if you have a valid student visa in the UK, interview can be done in the UK. But the problem is, you said that your student visa expires next year, June. What if the interview is not ready by that time? That may be the problem, because for NVC to schedule you in UK, you must have minimum of 6 months. 6 months clear legal status in the UK. So if they do not invite you for interview before June, that may be a problem. You may now need to start changing it. So except if you know that you intend to extend it, then you can apply for your case to be scheduled for interview in the UK. The next question. Oh, if yes, what proof of residence can I submit?
Oh, that was a continuation.
Yeah, it's a follow-up. Yeah. Yeah, the proof of residence is your student visa that will show your expiration. That's why I mentioned that you must have a 6-month clear period, because if your student visa is going to expire before they schedule the interview, they may reject the transfer request to transfer it to the UK. But if you can request it now if you plan to extend your student status in the UK or change status in the UK. As soon as you do it, we need to notify the NVC. But for now, the evidence you provide is the biometric passport of your passport, your visa page of your passport, and of course, I don't know what documents UK give student in the UK. In the US, I know that they give student I-20, and then, but I don't know what they give in UK. But whatever you have as evidence of your student status in the UK, that is what you will include in it. Thank you. Next question.
It's not that one. It's here. Let me give you this so that you can just answer those two questions.
Okay, thank you. Happy Thanksgiving. Happy Thanksgiving to you too. I overstayed for 2 years on B1, B2, but fortunately got married. Got my 2 years green card, expired though, then got 48-month extension while conditional removal ongoing. What's the question? Okay. Now that they are arresting overstay people, can I travel internationally without an apprehended due to my overstay record? Oh yes, you can travel. You are not in that category. Once you are given the conditional green card, your status has been adjusted. You are no longer in the category of overstay. No, you don't have any reason to be concerned. The only reason you should be concerned is if you have criminal record. For as long as you don't have criminal record, there's no cause for concern.
And then the next one is a 3-part one. Sorry, just 1 second. I just want to make it.
Are you able to determine, Marissa? Are you able to determine the next one, even though it keeps moving?
I got it. Okay. It's a 3-parter. This is part 1.
So I just move it to the right?
Correct.
Okay. Next question is a 3-part question. I came in with K3 visa, adjusted my status, but we never finished the process before divorced. Remarried a US citizen for over 15 years with kids, but couldn't adjust status. I just got my I-130 approved. What's the duration to file for I-601 after I-130 is approved? Once the I-601 approved, does that guarantee visa at home country, or you could still be denied visa despite I-601 approval? How long does it take to approve I-601? How much does your firm do it? Thanks for all you do. Okay. First and foremost, I think the first part of the question has been answered by the second question. If you enter the US with a K visa, you cannot adjust status in the US through another person. It is only the US citizen who brought you into the US as fiancé that can get you green card. Nobody else. If you divorce that person and you marry an American citizen, an American president, you cannot get green card in the US. So no matter how long, you cannot get green card. You are not eligible for green card. You have to go back to your own home country in order to get the green card. That is one of the major disadvantage of fiancé visa. Coming to the US as a fiancé, it is only the person who brought you in that can give you green card, nobody else in the US. So, like I said, this part is already answered by the second part, because you already know that you have to go back to your home country. Now you are talking about a waiver. Yes, you need unlawful presence waiver. You need unlawful presence waiver. And I'm going to tell you, it is not I-601. Based on this fact that you presented here, it is I-601A. I-601A. It's different from I-601. I-601 is the waiver of inadmissibility grounds. I-601A is unlawful presence waiver. It was a waiver that was created by President Obama when Obama was president. So you are not applying for I-601 because if you do, they will deny it. Because for you to apply for I-601, you have to go back to your home country first, you have to complete the immigrant visa process, go back to your home country, attend the interview, and be denied. Then you come back to file I-601. But I see based on this question, what you are trying to do is to waive the unlawful presence. So that is I-601A, unlawful presence waiver. So since you now have an I-130, just go ahead and file the I-601A, unlawful presence waiver. Upon the approval of that waiver, then you should go back to the NVC and National Visa Center and complete the process. Once you are scheduled for interview, then that is when you go back to your home country. If you have that I-601A approval, the embassy cannot deny you visa on that ground. If there are other grounds, they can still deny you visa on other ground, but not on the ground of unlawful presence. So if your only ground of inadmissibility is unlawful presence, that waiver covers it, nothing else. You don't need to do anything else other than the waiver. But remember, you need to apply while you are still here. That is I-601A, not I-601, because if you file I-601, it will be denied. You need to file I-601A. Now you are asking for processing time. I don't have that information. Is it possible to help me check the processing time for I-601A?
Oof, it's very long.
Yeah. While we are doing that, if I can go into the next question. I see that it's also asking for our fees and all of that. That is not something that we can discuss online. So you can reach out to the office. Which one is it?
Sorry, I thought it's okay. So this is the first part, but I have them all.
29.5 months.
Okay, I-601A, the processing time is 29.5 months. Let's see how many years is that. 24 months is 2 years. So 2 years and 5 months. Let's just say 2.5 years. So that's the processing time, 2.5 years. So I believe we have answered that question. Okay, the next question. Good afternoon, sir. I came into the US last year as a dependent to a J1 cultural exchange teacher. My wife's visa stated that 2 years home country rule not apply, but my mind says applied.
There's a second.
Please, what does this mean and what should I go with? Well, if yours says apply, it means that you have to go back to your home country at the end of the period of authorized stay for 2 years. However, you can apply for a waiver. You can go back to your home country, the embassy of your home country, and seek what is called no objection letter. With the no objection letter, you can apply for a waiver of the 2-year foreign residency requirement from the Department of State. That is all you need to do, since it's already clearly stated that you are affected. So the only thing you can, or two options, either you go back to your home country for 2 years and come back after 2 years, or you apply for a waiver. And in order to apply for a waiver, you need to contact the embassy of your home country and request no objection letter. That is that. The next question. Good afternoon, Dr. Asekun. I'm currently awaiting a decision on my employment-based adjustment of status. One of my references who submitted a letter of recommendation for me during my EB1 application is threatening to write to USCIS to withdraw its letter of recommendation. Please, what does this mean for my application? And what steps can I take legally to arrest this? Is there a continuation? Okay, to arrest this. That's probably the end. Honestly, this is a tough one. I really don't know what to tell you. I mean, I'm sure there must have been a misunderstanding between you and this person. Maybe you should find a way to resolve it, because the truth of the matter is that if immigration received a notice of withdrawal of the recommendation, that would negatively affect your pending application. I don't know why somebody who gave a letter of recommendation would want to withdraw it. Why? Why would that one? I don't know what to tell you, honestly, other than find a way to reconcile with the person and resolve it, because if you don't, it will certainly negatively affect your pending application. That's all I can say. Next one.
Oh, they were. Oh, sorry.
Oh, is there another one?
Okay, that's the one. Okay.
Thank you.
All the ones that you're answering are already screenshotted, so you can just keep going until you finish.
Okay. Good afternoon, sir. Thanks for all you and your teams do. You're welcome. May God continue to bless you all. Amen.
Amen.
Please, what do I need to show USCIS that I did engagement traditional wedding in Nigeria? Well, you can show them your invitation. If you have invitation, you can show it pictures of you and the fact. Engagement in Nigeria under Nigerian customary law is a big deal. There's no way you will not have tons of pictures. I mean, pictures from your family, pictures from the other person's family. You know that engagement involves writing letters. Your own family will write a letter to the other family saying that you see this beautiful flower in that other family that you want to pluck, you want to, all those things, those letters that you write to the other family, the response from the other family as well, pictures of the wedding, of the engagement, invitation for the engagement. I mean, even if you have a receipt for payment for vendors, maybe somebody who prepared the engagement cake, if maybe the hall, if you rented a hall for the engagement, the receipt of payment for the hall, if you have a contract with the hall, for engagement, you can't, there are tons and tons of evidence. If you really did engagement under Nigerian law that I know, engagement is something that you will have tons of evidence. The next question. I have adjusted my status through family-based petition. Will the cancellation of my pending asylum affect the EAD issued to my ex-wife and children? Have negative effect? Can I travel with the 2-year? Is there a continuation for this? I didn't see the question.
2-year. Let me see.
I didn't see a continuation. While you are looking at that, first and foremost, if you married a U.S. citizen and you left your previous wife and your children under asylum, if your green card was approved, why did you not include your children? You have the opportunity to let your U.S. citizen spouse petition for your children for as long as your children are under 18 at the time of marriage. You should not leave your children. I mean, I've seen this kind of scenario so many times. You see, on one hand, the father has green card through marriage. On the other hand, the mother and the children, they are in removal proceedings based on pending asylum. If you already got your own green card and you have minor children, why not include them in your own green card? the fact that you divorce their mother does not mean you are no longer their father. In fact, to be honest with you, under American law, when you apply for citizenship, they are going to ask you for evidence, to show evidence that you are taking care of the children. So it doesn't matter whether they live with you or not. It doesn't matter whether they are under their mother's application. Once you have a pathway to become a permanent resident, you should include your children. If your children is under 18 at the time of your marriage, it doesn't stop them from having the fact that they were on their mother's application does not affect you. It does not stop you from filing for them. So the person, your own wife or your husband who petitioned for you to become a permanent resident, that person should also petition for your children, except your children were already 18 and above at the time of your marriage. Otherwise, they should take care of your children.
So they just meant, can I travel with a 2-year green card?
That's the end of the question. Okay. So let me see. I have adjusted my status through family-based petition. Will cancellation of my pending asylum affect the EAD issued to my ex-wife and children? Have negative effect? Oh yes, you can. It may certainly have negative effect. And now I see that the next question is, can I travel with the 2-year green card? It depends on where you are traveling to. Are you traveling to the same country where you previously stated that your life was in danger? It doesn't matter whether you withdraw the asylum or not. Are you traveling to the same country? If you travel to the same country, it may jeopardize your ex-wife's case. It may also affect you because now they may see you as obtaining your green card by fraud or filing a frivolous asylum application, which of course is a permanent bar. Remember, I stated at the beginning of this podcast, maybe you joined late, I mentioned the policy, the new policy of the government. For the benefit of those who join us late, I want to go over the new policy. The new policy says that on November 21, 2025, which was last Friday, USCIS director issued an internal memo ordering USCIS personnel, that is their staff, to reopen, rescreen, and re-interview all refugee approvals, asylum approvals between January 20, 2021 and February 20, 2025. This covered the entire 4 years of President Biden. The memo ordered USCIS to stop adjudicating any adjustment application filed by asylees, refugees, and their derivatives approved during this time frame. It also stated that USCIS must terminate refugees grant if the reviewers find they were not eligible at the time it was granted. It also stated that refugees pending adjustment application must be terminated, must be denied if the refugee status or asylum status is terminated. The memo also specifically emphasized the persecution bar. The memo stated that refugees who have already adjusted status to lawful permanent resident will also be subject to the review. So there is no exception. And of course, USCIS also said that they have determined that comprehensive review and re-interview will be done for all refugees. So this may be a problem for your children. So even for you, despite the fact that you got your green card through marriage, so I will not advise you to travel at this time. It is not advisable that you travel at this time. Let me see the next question. Okay, the next question. Greetings, barrister. This must be a Nigerian. We don't call attorney
No.
in the U.S. barrister.
Right. You're
So
right.
this must be a Nigerian. Greetings, barrister. What could be done if you are denied a tourist visa because of lack of home ties, of which you have this document but forget them in the car? Is an explanation letter needed? Well, I've explained extensively the authority over non-immigrant visa. I think somebody else asked this question before. Unfortunately, you cannot appeal, you cannot do anything. The only thing you can do in this case is to reapply. So just reapply and make sure you go with all the evidence you have this time. Hopefully, the officer will reconsider you. Let me tell you, visiting visas can be denied with or without reason. It is part of the authority of the consular officers. These authorities were given to them and it is non-reviewable by any court. They are discretionary authority. So there is nothing you can do other than to reapply. Okay, the next question. Good day, sir. I presently have a 2-year green card and hopefully should apply for 10-year by next year. However, I work in another state from my home, at least from my spouse, while I'm still sourcing for work in the same state. And if I can't before applying, does it have any implications, sir? I go home at least 2 weekends in a month at the moment. Under this current administration, yes, you are in a very dangerous situation because you really have to have overwhelming evidence of your relationship in order to get the conditions removed if you are not living in the same state. It's going to be tough. When I say overwhelming, maybe your wife becomes pregnant. Yes, that would be overwhelming evidence. If you have a child together within this period, that will be your overwhelming evidence. But except you have overwhelming evidence, this will be problematic. You need to understand money is not everything. When you are talking about, if you are a foreigner in this country, your immigration status should come first, should be your priority. If you mess this up and you get into trouble, it will cost you more money, and not only money, inconvenience, and even risk of being removed, risk of your petition being denied, of you being placed in removal proceedings, of even losing this job that you think you are doing now. You have all those risks. So why not resolve this immigration problem first? Why not stay with your wife, live in the same place, get this done with before you start going out? If you are working in another state because of job, by the time you lose this green card, you are not going to have the same job. So you need to get your priorities straight. I mean, resolve the immigration problem first before you start thinking about working in another state. This is a conditional green card that is not even up to 2 years, and you are already working in another state, and you want them to believe that this is a legitimate marriage. It may be problematic, except you have the overwhelming evidence. Let's say your wife is pregnant. Yes, that will be overwhelming evidence, because if the marriage is fake, you will not impregnate your wife. So that would be my advice for you. If you don't have that, you better come back home now and look for something local. Money is not everything, because when the problem comes, money may not solve it. Next question.
These are the last ones.
Okay, this is the last one. Okay, then we go into the free consultation thing. Okay, I see it's almost 2 hours. Yeah. Okay, good day, sir. We used to be on asylum, but got our 10-year permanent residency through my wife's agency as a nurse. We have gone to Nigeria once, but with this new law, is it advisable to go to Nigeria again? And when can we file for our citizenship? Well, since your green card was no longer based on the asylum, you can apply for citizenship 5 years from the date of your green card. This is employment-based green card, so you can apply for citizenship 5 years based on the 5 years from the date of your green card. That's when you will be eligible for citizenship. But let me tell you this: the fact that you withdrew your asylum, that does not stop you from being accused of frivolous asylum pending, because now that they are going to revisit everything, even though in your case, maybe when they revisit it, they will see that your application was withdrawn. But just prepare in case you receive a letter asking you to come and explain. So just be prepared to prove what is called changed circumstances. You may have a fear of future persecution, and the fear may have been removed. So you have changed circumstances, or maybe you have fear. Maybe you are already persecuted in the past. Yes, you decided to move on because you now have other means of obtaining green card, and you can safely reside in the United States. That would be a change condition. That would be a change thing. So I believe that you should be fine. There is no cause for alarm. You should be fine.
Okay.
So I believe that's the last one for today. Which is I thought I saw one that was posted in blue.
We already answered that one.
Okay. That should be the last question. So what do we do with the?
Okay, so we're going to
So
do
so now we are going to do the
free consultation.
Are you going to come online and do
I'm
it?
just gonna put it here.
Okay.
So people will see it.
Okay.
So they can
So
see it.
right now we are going to do the free consultation. Are you sure they will see it?
Let me see. Can I see it?
Okay. Let me see. Let me do it from here.
So you're just going to do shuffle.
Oh no. Okay. Let me.
Oh, you know what? Maybe if we put
Yeah, that's a good idea. Yeah.
if we put the
Okay.
stand. Yeah, let's see.
We want to do the free consultation thing live so that everybody will see that there is no. No, you can you not? You can adjust that to.
But it'll be higher, not lower.
Yeah, that's the thing.
Oh, it'll be okay.
Yeah, that's the lowest it'll go.
That's the lowest, yeah.
Yeah, they can still see
But
it.
you know what? I may be able to. Wait.
They can still see it. Viewers can still see it.
No. Maybe if you hold it in front of you. Okay, I think it's visible now, but you will have to just to lower it.
So how do we lower it?
I mean, you will have to put it on your maybe. Yeah. Okay. Just don't move it. And then.
It's on my lap. I hope it's not going to
Yeah,
move.
so
Happy
we're gonna.
Thanksgiving.
Happy Thanksgiving. Bye. So we're gonna push the button now. These are all the names of the people that commented free consultation. We're gonna shuffle now.
So how do you shuffle?
I'm coming. Oh my god.
You need help?
Okay. There you go.
Okay.
Okay, we are shuffling now. So the
have a
winner is going to
name.
be
We have a name.
at random. Do we already
The
have a
name
name?
is
What's that? Oluwa Oluwatoyin Adefeso. Oluwatoyin Adefeso is our winner for this month.
Can you hear the applause?
No, I can't hear the
Okay,
applause.
okay, I'm coming. We have
The
to
winner is Oluwatoyin Adefeso. Yeah, the winner is Oluwatoyin Adefeso. Oluwatoyin, congratulations. Oluwatoyin Adefeso, congratulations.
Yay.
Congratulations,
So
congratulations.
remember that now this person needs to be following us. He should be a subscriber, and then he should send us the screenshot showing that he's subscribed to our channel.
Okay.
To the number.
Okay. Now that you have won, you have to do a screenshot of your subscription and send to what number is this going to send it to?
817
817
891
891 6655. Now that you have won, just do a screenshot of your subscription and send it to 817 891 6655. I also want to say, remember, this is the week of Thanksgiving. We actually came in today just for the primary purpose of conducting this podcast. So the consultation is not going to be this week. The consultation is going to be next week. It's not going to be this week. We will try as much as possible to do the consultation before our next podcast on next week, Wednesday. But the consultation is not going to be this week because we are closed right now. We just came in to do this. So we are going for Thanksgiving break. So happy Thanksgiving. Congratulations again. You continue. Oh, I think you adjusted that.
Yes, it's pretty close.
Yeah, it's too close. So I just realized I couldn't see myself. So until next week, we want to wish you happy Thanksgiving. Stay blessed. Remain hopeful. Don't let this period get you into depression. Remember, this period shall pass. No matter what we are going through right now, there is a time. I mean, anything that has a time limit, there is a limit to the power. The current president term limit will expire in 2028. So we will survive it. Just stay safe, be careful, and enjoy your Thanksgiving. In every situation, let us always remember to give thanks. Remember to follow us on all our social media podcast platforms. Follow us on Instagram, on TikTok, on Facebook, on YouTube, and on X. So remember to follow us. Until next week, I remain yours truly, Dr. Olu Asekun. And with my team here, we are saying Happy Thanksgiving.
Happy Thanksgiving.